which the 1992 New Jersey law was seen as a conflict of the Professional Amateur Sports Protection Act, or PASPA, which had prohibited all lotteries except those under state law at the time that the act was passed. At that time, Delaware, Montana, Nevada, and Oregon all had state laws providing for sports wagering. However, Nevada was effectively the only state conducting sports wagering in a meaningful way. So New Jersey in 2012 had passed a law authorizing sports betting, and that law was challenged by the 5 major professional sports leagues: the NBA, the NFL, the NHL, MLB, and the NCAA all challenged New Jersey, sued them twice, and the second time the Supreme Court did issue a rule striking down that law. So in 2018, effectively, is when sports wagering became legal in the United States if states decided to authorize it. So as a result of the Supreme Court decision, states can legally regulate wagering on sporting events. Since that decision, more than half the states have taken action to legalize sports wagering. Sports wagering is currently offered in 30 states and the District of Columbia. It is legal but not yet operational in another 3 states. And Connecticut, New Mexico, North Carolina, North Dakota, Washington, and Wisconsin do not have state-approved sports betting, but they have worked with the Native American governments to authorize it at tribal casinos in those states. Intrastate mobile sports betting has been implemented or authorized in 19 states in the District of Columbia, allowing bettors to place bets from their phone or their computer. In Tennessee and Wyoming, sports betting is only available online. And among those states that have not broadly legalized mobile sports betting, Mississippi and Montana allow bets only from a mobile phone while it is placed on the casino premises. So while 30 states have legal casino operations, states without casino-style gaming, including Montana, New Hampshire, Oregon, and Tennessee, still have legalized sports betting and offer it as a lottery product. Of the 15 states that introduced sports betting legislation in 2021, 9 of those do not have legal casino gaming. On page 2 of my memo, you can see a map provided by the American Gaming Association, which shows the legal sports betting status in the United States. So 30 states do have live legal sports betting up and running at this point. In the Kansas region, those states do include Arkansas, Iowa, and Colorado. In addition, 3 states have legalized sports betting, but those systems are not at this time operational, are not up and running. In the Kansas region, that would include the state of Nebraska. And then 5 states in the United States have active or pre-filed legislation and relating to sports betting, and that includes the state of Kansas and Missouri. Finally, 12 states had no legislation in 2021 pertaining to sports betting, including the states of Oklahoma and Texas. So looking at the tax rates and licensing fees, most states that have legalized sports betting impose somewhere between a 5 and 20% tax rate, but there is significant variance among the states. Some states, such as Illinois and Pennsylvania, also generate sizable funds through licensing fees. The state of New Jersey, which currently has the largest sports betting market in the nation, brought in $49.4 million in new tax revenue in calendar year 2020, with mobile sports betting accounting for almost 95% of the total amount wagered in the state. Pennsylvania brought in a total of $38.7 million in state tax revenue, with approximately 75% of it attributable to mobile sports betting. Comparatively, the revenues for non-mobile sports betting states are not as robust, and I do have a table here that we'll go through. The state of Arkansas, for example, collected $312,000 in tax revenues without having authorized mobile sports betting. However, they are looking to give final approval of mobile sports wagering on January 28th. Delaware, again, has not authorized mobile sports betting, and they've taken in $11 million in fiscal year 2022. Mississippi, $4.3 million. New York, $1.07 million. Indiana, getting to our first state that has legalized mobile sports betting, $12.1 million. Iowa has a good breakdown of their sports betting based on the retail versus the mobile. So you see of the breakdown of Iowa's fiscal year 2020 retail net receipts was $11.9 million, whereas their mobile gaming alone was $13.7 million for a total tax collected of $1.7 million. So those first two numbers are just on the total net receipts, and then that third number is the actual tax collected off of that. You can see over a year in Iowa, the mobile net receipts over doubled, and the tax collected increased to $3.1 million. Again, New Jersey, the lion's share of their $49 million in total revenue comes from the internet sports betting. Another item of note when it comes to mobile sports betting is that some states choose to, prior to authorizing mobile sports betting, will require that an individual go to either a casino or whatever the designated location is to authorize that mobile account. And again, what the revenues seem to show is that when that sort of condition is put in place, that the revenues do decrease from the mobile sports betting side, that people tend not to engage in mobile sports betting as robustly if they're required to go to a physical location to enact their account. The final table in your memo has a full listing of states that have legalized mobile sports betting with selected categories, and I'll just point out a few of them in our region and let the committee review all of the states on their own. So looking at Arkansas on page 3, Arkansas has a tax rate of 13 to 20% on gaming revenues, and that is a graduated rate. So the first $150 million they take in sports betting revenue is taxed at 13%. Once they cross that $150 million revenue threshold, the tax rate then jumps up to 20% on revenues over that. Arkansas does not have any licensing fees, and the majority of gaming revenue goes to the state general fund, with race purses, county, and city governments as other beneficiaries. Looking on page 4, the state of Colorado has a 10% tax rate, and they do have licensing fees. They have a master license fee of $2,000. And then they have retail operator and mobile operator fees of $1,200 each, and those fees are subject to renewal licensing. The proceeds in Colorado, sports betting tax revenue goes towards funding the implementation of the state water plan and other public purposes. Moving on, we'll look on page 5. The state of Iowa has a 6.75% tax rate. They do have licensing fees of a $45,000 initial fee and a $10,000 annual renewal license. Proceeds in Iowa are distributed in the Sports Wagering Receipt Fund to be used as directed by the General Assembly. I will update your spreadsheet, but I'll give you these numbers now. The state of Nebraska has a 20% tax rate. Nebraska does not have any licensing fees, and their proceeds are broken down as follows. 70% is allocated to property tax relief, 25% to local governments where gaming is authorized, 2.5% to the general fund, and 2.5% to the problem gambling fund. One other item of note is the federal government does also levy an excise tax at a rate of 0.25% of the handle or the bet placed. So the federal government also does tax sports betting wages as well. Mr. Chairman, that would conclude my report. I'd be happy to stand for any questions at this time.
We have questions for Andrew. Senator Hosher.
Thank you, Mr. Chair. Could you please remind me, as far as some of the states that do not have the mobile-based function, was some of that because of the timing of when they initially implemented, or was there something else, or does it just vary from state to state? I was thinking there were a couple of prevalent factors.
I believe it varies from state to state, but I'll have to check on that for you and I'll follow up. Obviously, some states just have tighter control on the authorization of sports betting and don't want that authorization, but I can follow up on you with that.
Senator Reichman.
Thank you very much, Mr. Chair. And I'm pretty novice on this whole sports betting deal. If, let's say we pass it and let's say we're going to put it on the mobile. Now, can people from other states still bet using it? Let's say Missouri, for instance. Could they come on over and use or is this just for people in Kansas that can bet?
I believe it would depend on how the law is structured in that, but typically different states will require you have to be a resident. States can require that it's legal as long as the bet is placed in the state. So if it's legalized at a casino or something like that, anyone going to that casino would be able to place a bet.
Thank you for that answer. Thank you.
Senator Fascodo.
Thank you, Mr. Chairman. Andrew, thank you so much. Is there an age requirement addressed with this legislation to those who could make these bets?
Yes, I believe the typical age is 21. So I think most states require that a gambler must be 21 years old to place bets.
And so when they decide to cast their bet through the mobile option, how is it determined their age?
Typically, the controlling entity would require some sort of upload of a driver's license or verification document before an individual would be able to place a bet.
Because I know in past hearings we were concerned about that age range. And to the Senator Cindy Holscher's comment in your presentation, it is legal but not yet operational in 3 other states. So, and then at the end of your presentation, you mentioned the federal fee to the handler. Can you just explain, so the whole operation piece, the mechanism of how it works? So I go and get a license or get my mobile phone activated at a casino, and then just tell me how that works step by step to cast that bet.
Sure. So yes, that was one of the items I'd mentioned, is that some states you're able to just set up your account online. You enter in your information. Presumably your account goes through some sort of review, but it's activated virtually. Other states will require, in order for you to activate sports betting on your phone, right, in order for you to be able to place a bet on your phone, you have to go into some site, be it a casino or some authorized site that's authorized to verify your information in order to activate that account. So it's a different based on state structure of how they want to require that mobile sports betting authorization.
Mr. Chairman, Andrew, so is there then an app on your phone that gives you different events that are taking place for you to bet on? And then who do you submit your bet to, and who pays you? Because I might want to, make a bet. I'm trying to make some money too, Mr. Chairman. Thank you, Andrew.
Yeah, absolutely. So, yes, states typically, whatever the entity is that is responsible for the betting will develop some sort of app, some sort of interface that allows them to place the bet. And again, it's kind of dependent on how that app is built, but will typically show different wagers that you're able to place, and then you'd be paid out through that app.
Okay, thank you. Further questions? Not seeing any? Thank you, Andrew. It's a good presentation. It's good to learn about these other states and kind of what they're doing. And so, yeah. We'll move on to our next presenter, Jason Long. He's going to do it virtual. Jason, go ahead.
Can you hear me, Mr. Chairman?
We can.
Okay, good. You have in front of you a chart comparing sports wagering legislation that moved through the legislature last year. The middle column you'll see on your chart is substitute for Senate Bill 84, which was worked in this committee and passed the Senate and sent over to the House. The House Committee on Federal and State Affairs took that bill and they put their own provisions for sports wagering into Senate Bill 84, passed it out of committee, and it is now currently sitting on the House floor over there in the House. And so that is the far right column, the House position, comparing the provisions of the two versions of Senate Bill 84. I wanted to start out before I get into the chart, just to remind this committee, for anybody who's new on the committee, that gambling is generally illegal in Kansas. We have a criminal statute that prohibits any gambling activity. There are exceptions for what has been authorized by the Constitution and by statute, but if it's not specifically authorized, then it is illegal criminal activity and can be enforced through criminal penalties. I will also point out that in Kansas, gambling, lottery gambling that we know of as lottery tickets and casino gambling has to be owned and operated by the state of Kansas under the Constitution. And so that's why we have the Lottery Act and the Expanded Lottery Act. And under those provisions, the state, through the Kansas Lottery, contracts with retailers and managers to manage gambling on behalf of the state, but the state is still ultimately owns and operates and controls the gambling activity in the state of Kansas. And so you will not have any provisions in Senate Bill 84 referring to licenses, because we don't license gambling activities. We contract with managers for gambling activities. And so you'll see in Senate Bill 84 really uses that existing structure under the Lottery Act and the Expanded Lottery Act to administer sports wagering in the state of Kansas. Starting on page 1 of the bill, probably the key difference in the bill is who is authorized to conduct sports wagering on behalf of the state. The Senate position you'll see limits that only to the casino managers who already have a management contract with the state to manage a casino. So there's 4 casino managers currently in the state. Those casino managers would have the opportunity under the bill to enter into sports wagering management contracts with the Kansas Lottery to conduct sports wagering. The House is more broad. The House position would not only allow casino managers to contract with the state, but it would allow racetrack facility gaming managers. And so these are the managers that would conduct slot machine gambling at an active horse or dog racetrack in Kansas. We don't have any of those currently, but if we were to have a racetrack facility gaming manager under the House bill, they could also contract to conduct sports wagering. The House position would also allow up to 1,200 sports wagering retailers to conduct sports wagering on behalf of the state. This is modeled after our lottery ticket retailers under current law. And so the lottery would enter into contracts with these various retailers for them to provide sports wagering on behalf of the state. And as part of that contract, the retailer would take a commission on those revenues generated from that sports wagering activity. And finally, the House position also allows the lottery on its own to conduct sports wagering. So it could actually have its own statewide app that people could create an account with and place wagers with the state without going through a casino or a sports wagering retailer. Both bills, however, do clearly provide for internet sports wagering through what is called in the bill an interactive sports wagering platform. You can think of that essentially as a sports wagering app that the user would have on their PC or on their phone, and they would create an account. They would have an electronic wallet connected to that account. They would place a wager. If they lost, the money would be debited from their electronic wallet account to the manager that they were placing the wager with. If they win, the prize is paid by the manager to the patron, typically into their electronic wallet account. And so moving on into the next section there, the bills do differ somewhat on the use of that sports wagering app. Under the Senate position, each sports wagering manager, so each casino manager, could use up to 3 different apps. The apps must be approved by the executive director, and there must be background checks done on each app provider. So this is looking at the companies that are providing the application. All the wagers that are placed through that mobile app have to be from persons who are physically located in the state at the time the wager is submitted. So there's a geolocating requirement for placing a mobile wager to ensure that the individual is located in the state. The individual does not have to be a resident of Kansas, but they do have to be physically present within the state boundaries in order to place a legal bet with the sports wagering manager. The House version would have the executive director of the lottery select one application and contract with that application. It would be made available to any other sports wagering managers for their use. A casino or racetrack manager could request an additional application. They would have to request that by applying to the lottery and get approval by the lottery for that additional application. And in addition to that, they could request an additional graphical user interface. And you can think of this as kind of the front piece of the app that interacts with the user. And so they could style one for their particular casino and have that approved by the lottery. And that's what appears when the patron engages with that particular sports wagering manager. On to page 2, as I mentioned, the House position allows for contracts with sports wagering retailers. And so there are provisions, the provisions for qualification and contracting with these are essentially the same statutory requirements for lottery ticket retailers. So we're not rewriting new law there. We're using the same existing law for lottery ticket retailers under the House bill. There would be a commission. Sports wagering retailers could only offer tier 1 wagers, and I'll get into that a little bit later, but tier 1 wagers essentially are defined in the House bill as those that are based solely on the final score or final outcome of a sporting event. There would be no in-game betting at a sports wagering retailer. You could only bet on whether or not the Chiefs win or lose, for instance. As noted, because of the limit on who can conduct sports wagering, there is no provisions for that under the Senate bill. In addition to that, The House added a provision to authorize the Attorney General to file an action within 90 days of the effective date of the bill on the question of whether or not a contract with a sports wagering retailer would be a breach of a casino management contract. And so there are provisions for bringing that action and actions by a casino manager to sue for breach of such contract if they felt a contract with a sports wagering retailer would be a breach of their casino management contract under the Expanded Lottery Act. So there's some litigation provisions there on the bottom of page 2. Going to the top of page 3, you'll see this is the tier 1 and tier 2 wager distinction. There is no such distinction in the Senate. All types of wagers are essentially permitted as defined under the Senate position by those casino managers. Under the House, there's the distinction between tier 1 and tier 2. Tier 2 wagers are essentially any other wager that isn't a tier 1 wager. While sports wagering retailers are limited to tier 1 wagers, all other sports wagering managers could offer tier 2 wagers. So that'd be the casinos and the racetracks and the lottery itself. In addition to that distinction, the House also requires that for those tier 2 wagers where you're using in-game data, the sports wagering manager must use official league data for determining whether or not those the outcome of those wagers, and that data, with the caveat that that data is readily available on commercially reasonable terms from the league. But if that is the case, then the casino or racetrack must use that official league data for those tier 2 wagers. Going into page 3, there are some relevant definitions there. I will point out the ones I think are somewhat significant between the two bills, namely this definition of a sporting event is different. Under the Senate bill, it's any amateur or professional athletic event, motor race event, horse race, or any other competitive event authorized by the executive director of the lottery. There is an explicit exclusion of any greyhound race or any interscholastic sports event in kindergartens K through 12 and the grades K through 12. So it's excluding those school sports events. Over on the House side, it's any professional or collegiate athletic event, motor race event, or other special event. And then the specific exclusions are any horse races that are already governed by the Pari-Mutuel Racing Act. So pari-mutuel wagering would not be considered a sporting event for sports wagering purposes. Excludes any greyhound race and excludes athletic events where the majority of the participants are under 18. So it bases more on age of the participants for those those competitive events among minors, whereas the Senate is more based on whether or not it's a school-sponsored event for that exclusion. And so that's really a key. I will also point out on the House bill, sports wagering explicitly excludes pari-mutuel wagering, as I mentioned before, and any fantasy sports league activity. That is not considered sports wagering for purposes of the bill. And then on bottom of page 4, these are the management contract provisions for managing a sports wagering on behalf of the state. And these are essentially like the taxes that Andrew mentioned in his presentation. The state doesn't quote unquote tax sports wagering because it's done on behalf of the state. The state already owns and operates it. But this is the percentage that the state would retain of the sports wagering revenue generated from those sports wagers placed with a manager. And so under the Senate bill, you can see for those that are placed in person at the casino, where the person walks on to the actual physical premises, the state would retain 5.5% of the revenue. And for those that are placed electronically online, the state would retain 8% of the revenue. The Senate also has a particular provision where 2% of all sports wagering revenue would go to the Problem Gambling and Addictions Grant Fund. So there's an additional funding stream for that particular fund. The House bill changes the percentages. The state would retain 14% of those placed in person at the casino or racetrack, and the state would retain 20% of the revenue that was placed through the online application. And the state does not earmark any percentage of revenues going to the Problem Gambling and Addictions Grant. Moving into the actual wagering activities by the sports wagering managers, both bills contain a provision for agreements with a sports team. Under the Senate provision, a casino manager could contract with a sporting facility to offer sports wagering at that facility. Obviously, all the wagering would be conducted by the sports wagering manager on behalf of the state. It would also be required to be conducted online through the online application. And the Senate narrowly construes a sporting facility as defined to be only the Kansas Speedway located in Wyandotte County. That would be the only facility that a casino manager could contract with. On the House position, it allows the lottery or casino or racetrack manager to enter into a marketing agreement with a professional sports team for the promotion and advertising of sports wagering. Sports wagering could be conducted at the primary facility of that sports team through online applications or through kiosks available on the facility premises. The agreement must be approved by the lottery, and professional sports teams or any baseball, basketball, football, ice hockey, or soccer team that competes at a major league level and is primarily located within the state of Kansas. The only team that meets that definition currently would be the Sporting Kansas City Soccer Club over in Wyandotte County. Both bills contain prohibitions on certain sports wagers being made and has obligations on the managers to enforce those prohibitions. The Senate requires commercially reasonable methods to prohibit such wagering. The House bill just requires reasonable methods. One key difference in the House bill involves the sports governing body for a particular sport. So this would be like the NFL, the NBA would be the sports governing body for their respective sports. And under the House bill, a wagering manager would be required to report illegal, suspicious, abnormal wagering activity that concerns the integrity of the sporting event to that particular sports governing body, and would have to cooperate with investigations conducted by the sports governing body. The sports governing body is not mentioned in the Senate version of Senate Bill 84 at all. It is not referenced. That is purely a House provision. The Senate also has some provisions regarding patron accounts. It allows a bettor's account that's held with a casino wagering manager to be funded through cash, ETFs, wire transfers, debit, credit cards, online money transfer systems, promotional funds provided by the manager, and any other payment method approved by the lottery. The House position is silent on individual bettor accounts and how and any restrictions or regulations on those. Moving on to page 6 of your chart, both bills contain the same restriction on persons under 21. They are prohibited from placing any sports wager. There are also similar provisions on allowing a person to request that they be placed on a restricted bettors list with the state, and that list would be then transmitted to all the various sports wagering managers with the state to prevent that person from placing a wager with the manager. There are provisions for restricting certain sporting events. Under the Senate bill, the lottery may restrict a sports wagering, a sporting event, and then give notice to all the wagering managers that bets cannot be placed on that sporting event. Under the House bill, a sports governing body would notify the lottery if it wanted a particular event to be restricted. The lottery would review that request and either grant or deny that request on those restrictions. Again, under the House bill, because the lottery owns and operates sports wagering, they could still restrict a particular sporting event if the lottery chose to do so. There are restrictions on who can place a bet. The Senate provisions restrict a relative living in the same household as a casino manager employee, application employee from placing a wager with that particular manager or online application. But the relative living in the same household could still place a sports wager with an unaffiliated sports wagering manager or online application. The House position just has a blanket prohibition on relatives living in the same household as those key individuals. Both bills do have restrictions on owners, officers, athletes, coaches, employees of teams that are participating in a sporting event. They also have restrictions on directors, officers, employees of any player or referee union from placing sports wagers. And then the House bill also restricts directors, officers, and employees of sports governing bodies. On to page 7 at the top, there in the middle, big section in the middle there on maintenance of records. Both bills contain certain requirements for for sports wagering managers to maintain records. The Senate requirement is only for persons who wager $10,000 or more within a 24-hour period. The manager must maintain those betting records for at least 30 days and provide them upon request by the Lottery or the Racing and Gaming Commission. On the House, it's a broader requirement. Each sports wagering manager has to maintain those records for at least 3 years. There's no caveat on the betting amount or the time period in which the wagers were placed. It also includes video recording of any in-person wagering. It must be made available to the Lottery and the Racing and Gaming Commission on request. And if there is a data sharing agreement in place between the sports governing body and the lottery, then that information should be provided to the sports governing body, except for the video recordings, which do not get disclosed. There are causes of action in both bills for improper influence of a betting outcome. The state has that cause of action under the Senate bill. The House bill also grants that cause of action to a sports governing body to bring against an individual who unduly influences a sports event outcome. On the next page, page 8, you'll see the comparison provisions for the Sports Wagering Receipts Fund. This is modeled after the Expanded Lottery Act. This is basically how the revenues get distributed under the sports wagering provisions. Each manager would have a separate account in the Sports Wagering Receipts Fund. Their sports wagering revenues would be deposited into that account. And then each month, the executive director would determine how much is to be paid out to the individual managers based on their contractual portion of revenues. There is a slight difference in that the House would do monthly deposits into the Sports Wagering Receipts Fund. The Senate bill would do weekly deposits. The Senate also has a provision that would allow a sports wagering manager to carry over negative sports wagering revenues from one reporting period to the next and offset revenues in a subsequent period. And so that is unique to the Senate position. There are also provisions similar to each other on background check certifications to include sports wagering managers and the online application providers. The Senate does cap the background at contractors who are providing goods or services in excess of $250,000 each year. There is no limitation on the background checks under the House bill. On page 9, the rule and reg authority, you can see there. The primary difference here is that the Senate position grants rule and reg authority over sports wagering to the Racing and Gaming Commission with respect to advertisements. Under the House position, it would be the lottery that would be adopting those rules and regulations with regard to advertisements. But as you can see, the actual prohibitions on advertisements are very similar between the two bills. There are provisions in both bills that have the lottery adopt rules and regs regarding sports wagering and how it's being conducted. Those are obviously broader on the House position because of the broader scope of potential sports wagering managers under that bill. And then at the bottom of page 9, you can see there are provisions in both bills requiring the governor to negotiate in good faith if an Indian tribe requests a gaming compact negotiation regarding sports wagering. On the next page, page 10, you see both bills do create a white collar crime fund to assist the Attorney General and potentially the Racing and Gaming Commission in the investigation and prosecution of crimes related to unlawful wagering. The primary difference between the two versions is who is administering and expending those funds. The Senate position would have the governor administer the fund, and the Attorney General and the Racing and Gaming Commission would annually submit budget requests to the governor for funds from that white collar crime fund for their purposes. The House position would have the fund administered solely by the Attorney General, who would then transfer monies as necessary to the KBI for investigation purposes. Under both bills, the fund would receive the first $750,000 in sports wagering revenue that is credited to the lottery operating fund. So that first $750,000 retained by the state in sports wagering revenues would go to this white collar crime fund each year. Under other criminal provisions, both bills create a new crime of misuse of non-public sports information. This is attempting to financial gain by using non-public information and placing a sports wager. The penalty under both bills is a level 5 non-person felony. Both bills make it a crime to conduct unlawful sports wagering, and you can see those the criminal activity is relatively similar. Both are a level 8 non-person felony. There's also the same provision in both bills that exclude sports wagering from the definition of bet under the criminal gambling statutes. And then also with regard to criminal penalties, on page 11, you see the Senate bill amends 2 existing criminal statutes regarding sports bribery and tampering with a sports contest to increase the penalty level from a level 9 to a level 8 non-person felony for both of those crimes. The House bill only addresses sports bribery and would raise that penalty from a level 9 to a level 5 non-person felony. The House did include some provisions for the prosecution of unlawful gray machines. I believe this was a request from the Attorney General's office to give them specific prosecutorial power jointly with the Racing and Gaming Commission on gray machines. That provision is not included in the Senate bill. At the bottom of page 11, both bills do contain restrictions on online lottery games. These would be lottery games that the Kansas Lottery would provide through an online application. I think the concern with this is that they not be basically the same as casino games that the casino have exclusive right to offer under their casino management contracts. And so you can see there is a difference as to how they describe those online lottery games between the Senate position and the House position. But essentially it's the same prohibition to prohibit the lottery from conducting online lottery games that are too similar to casino gaming. And finally, if we move to the back of page there on page 12, You see provisions regarding the Problem Gambling and Addictions Grant Fund, the Senate bill, in addition to the dedicated 2% revenue funding source, also made some changes with respect to the fund to ensure that monies in the fund are used to create helplines, treatment, research, education, prevention of pathological gambling. It also increased the annual transfer from the state gaming revenues fund to the Problem Gambling and Addictions Grant Fund from 80,000 to 100,000. The House bill simply makes that additional, that increase in that annual transfer. It does not include any of the other provisions from the Senate bill. And then included in the House position is an authorization for the a vote again in Sedgwick County on the placement of slot machines at a racetrack facility located in Sedgwick County. Some of you on the committee may remember bills that proposed this authorization. Those provisions were added to Senate Bill 84 on the House side. And finally, the House also included provisions under the State Debtor Set-Off Act to include sports wagering retailers as an agency of the state to hold prize winnings in the event a patron who placed a wager does owe a state debt. And so those prize winnings could be used to set off that debt. Obviously, both bills were designed to go into effect on July 1st, 2021. And so if the committee were to move forward, I would recommend taking a look at the dates in the bills to see if those need to be moved up a year to allow for rule and reg adoption and implementation of the provisions. With that, Mr. Chairman, I'd be happy to answer any questions.
Okay, thank you, Jason. That's a great report. Questions from the committee on the different bills? Senator Longbine.
Thank you, Mr. Chairman. Jason, just for clarification point, we talk about House position. If I remember right, this is a House committee position because this is not, their bill has not passed their floor. Is that correct?
That is correct.
Okay. Appreciate it. Thank you.
We just wanted to make sure we got all the different views, the committee's up to speed, kind of a side-by-side of what we've done. And you know, I think, you know, they did both, Jason and Andrew did a great job of kind of explaining what we're missing out on here. So this is going to be definitely a focus to figure out how to move forward, how to get this bill completed. Other questions? Senator Fasco-Doe.
Thank you, Mr. Chairman. Jason, are you still there?
Yes, I'm here.
Does this, the Senate version, does it include the piece that, and I may be speaking of another bill, but does this include the measure that Senator Hildebrand, the vice chair, offered an amendment for scholarships for certain students? Are you familiar?
No, I don't. Yes, I know. I think I know what you're talking about. I don't believe the final Senate position contained the white collar crime scholarship provisions, but I will double check on that to make sure I didn't overlook that.
Okay, and then if you could just, for the record, on page 12, so what was the original date that the legislature passed to say that Sedgwick County could not have a revote on slot machines in Sedgwick County?
Well, the original authorization came in 2007 when the Expanded Lottery Act was passed. Sedgwick County had that vote shortly thereafter, and the vote failed to pass to authorize placement of slot machines. And so what these provisions in the House bill would do would authorize either the Board of County Commissioners on their own, or if an adequate and proper petition is submitted to them, to place the question on the ballot again as to whether or not slot machines would be placed at Wichita Greyhound Park.
Well, I hope we get to do that. I have two more quick questions, Mr.
ahead.
Chairman. So on page 7, Jason, when you talk about the person wagering the $10,000 or more in a 24-hour period, is that $10,000 at one time, or can it be multiple bets placed?
It's over a 24-hour period, so it could be a series of bets that total, $10,000 within a 24-hour period, or it could be a single wager of $10,000 or more would also trigger that record requirement.
Okay, thank you. And then the last question. So in your early presentation, you talked about dog racing. I thought we went to just horse races. Can you elaborate? Thank you, Mr. Chairman.
Well, greyhound racing is still not only allowed under the Kansas Parimutuel Racing Act, but certain dog races, live greyhound races, are required for certain racetrack facilities to have slot machines placed in those facilities. They have to run a certain number of live races. And if the racetrack, such as the Wichita Greyhound Park, is only constructed for greyhound races, those would be greyhound races. There have been bills and legislation proposed to eliminate greyhound races and ban greyhound racing in the state of Kansas, and of course amend those provisions so that's no longer a requirement. But that is not part of Senate Bill 84. The only thing Senate Bill 84 does is it doesn't include greyhound races as a sporting event on which you can place a sports wager under the law.
Okay. Senator Hosher?
Thank you, Mr. Chair. Under the part where it says event restrictions, the Senate position has fewer entities that can restrict. Is that because the House wants to allow for more restrictions potentially for certain events?
The Senate position really leaves it solely with the lottery to determine whether or not a sporting event is going to be restricted, which would be the case on the House as well, given that the lottery is the owner and operator of sports wagering. The House position simply adds the additional allowance to allow a sports governing body such as the NFL to request that a particular event that the NFL oversees be restricted by the Kansas Lottery. And there are provisions in the House bill to allow for an emergency restriction followed by a full review, or if the request is made timely enough, to allow for a review by the executive director and then a grant or denial of that request by a sports governing body.
Okay, so it's not necessarily that the House position allows for more potential restrictions, it's just more bodies that can make the restriction. Am I
There's
reading that
one
right?
additional body that can request a restriction, yes.
Gotcha. And then I do have another question, if I may.
Go ahead.
On the very first page, I was just having a little bit of hard time understanding. So Senate position 4 currently in the state as far as managers that could enter into the sports wagering. Per the House position, I guess I'm not reading it correctly, maybe. They can go up to 1,200, so essentially we could have more partners in it. Am I interpreting that correctly?
I'm guessing it's like gas stations and different places.
Yeah, that's, yeah.
Yeah. I think it's best to think there's 2 separate categories of managers that the state can contract with. There's what we do under the Expanded Lottery Act with the casinos, and if there's ever a racetrack facility management, we could do it with a racetrack facility as well. And those managers would operate a lot like the lottery and offering both tier 1 and tier 2 wagers, doing it through online mobile apps. The 1,200 number is tied to the sports wagering retailers, which act more like a lottery ticket retailer. So this would be like your grocery stores, convenience stores, potentially restaurants, that like sports themed sports bars and grills could potentially apply and be a sports wagering retailer. And they would operate more under individual contracts with the lottery, like a lottery ticket retailer does.
Does that answer your question?
That does. And while there will not be any wagering, Mr. Chairman, our boys play each other tomorrow in basketball.
That's right. That's right. Well, we'll see if we can't wager a pop on the side, so. Okay, Senator Reichman.
They pretty well answered. I was just going to mention, I don't know if anybody else that didn't get page 11 besides me.
Yes, we did not.
It's on purpose. I'm joking.
I probably couldn't understand it anyway. That's probably why I didn't get it. Thank you.
I didn't get page 11 either. Okay, thank you. Okay. I thought this, is there any further questions or comments? Senator Longbine.
Thank you, Mr. Chairman. I just point out to the committee, I think one of the major differences between the House and the Senate positions of last year and previous years is more of a philosophical determination. The Senate, under the Senate position, the casinos take all the risk, and under the House version, the state takes the risk. And I think that's a major distinction that we need to keep in mind as we move forward.
Duly noted. I think you've done some great work on this. We got to figure out how to try to get this across the line. I think it's good to really understand both bills and what's going on in the country. Let's get this one done. But I think it's some great questions too here today. You know, my intention, I'm going to be meeting with some of the players over the next couple weeks. I'd like to see either take 84. I don't know if it's still around. They might have used that bill for something else. But there's multiple vehicles around. But I would, you know, I'd like to see if we can't come to a compromise with everybody and maybe run it through the process so everybody gets to talk about it one more time. So that's my intentions, trying to find where we can to fix this thing and see if we can't do a little magic, you might say. With that, I think I wouldn't mind, you know, since we're so close to Iowa and it seems like they've done well on the mobile piece, maybe having a copy of the Iowa legislation. You know, I think we're hung up more on the 1,200 vendors, the local, the Wichita piece, but if you look at the states that have the mobile, that's where the bulk of the revenue's at. We need to figure out these other details because we're missing out on, I don't know that we're equal to Iowa, but a nice chunk of money. And so we're going to see what we can do to fix this. So, yeah, but if I could get a copy of the Iowa, I'd like to look at that a little more in depth. If there's no other questions, anybody have any questions, comments? Not seeing any. That's the only presentation we had for today. Tomorrow, we'll have bill introductions, presentation, overview on elections, and then next week we'll get into hearings. So with that, we're